Summary of the case. The case of South Carolina v. Doe centers on a state law that prohibits transgender students from using public school restrooms that align with their gender identity. The legal challenge was brought by a transgender student identified as John Doe, who was disciplined and eventually forced to withdraw from a South Carolina public school for using the boys' restroom. A federal appeals court, the U.S. Court of Appeals for the Fourth Circuit, granted an injunction, ruling that Doe must be allowed to use the boys' restroom while the case proceeds. The court cited its own 2020 precedent, Grimm v. Gloucester County School Board, which established that such policies likely violate both the Constitution's Equal Protection Clause and Title IX of the Civil Rights Act. South Carolina has now filed an emergency request with the U.S. Supreme Court, seeking to pause the Fourth Circuit's order and enforce its state law. The Supreme Court's decision on this emergency application will be a significant indicator of how the court views these issues. Reasons and consequences. The primary reason for South Carolina's appeal is to challenge the Fourth Circuit's precedent and protect a state law that they argue reflects the will of its citizens. The state contends that the law is a valid measure to protect student privacy and safety. They argue that the Fourth Circuit's ruling is a discredited outlier that is incompatible with the Supreme Court's recent decision in United States v. Scrimeti, which upheld Tennessee's ban on gender-affirming care for minors. The consequences of this case are far-reaching. If the Supreme Court grants a stay and sides with South Carolina, it would signal a potential reversal of the legal protections that transgender students have been afforded in the Fourth Circuit, and could embolden other states to pass similar restrictive laws. It would also create a legal standard where policies based on biological sex assigned at birth are viewed as permissible, potentially undermining the application of Title IX to gender identity. Conversely, if the Supreme Court denies the state's request and allows the injunction to stand, it would reinforce the legal precedent that transgender students are protected under federal law. This would be a victory for LGBTQ+ rights advocates and would likely lead to similar legal challenges against other states with comparable laws, confirming that such policies constitute illegal discrimination. Analysis. The legal arguments hinge on two key federal laws. The student's case is built on the Equal Protection Clause, which prohibits states from denying any person the equal protection of the laws. The argument is that the law treats transgender students differently from cisgender students on the basis of sex, an impermissible classification that is not supported by a compelling government interest. The second core argument is based on Title IX, which prohibits sex-based discrimination in any educational program that receives federal funding. Legal precedent, particularly the Supreme Court's 2020 ruling in Bostock v. Clayton County, has established that discrimination based on gender identity is a form of sex discrimination. South Carolina, however, is arguing that Title IX's specific language regarding sex-segregated facilities creates an exception to this interpretation. The state's reference to Scrimeti is a strategic move to suggest that the Supreme Court's conservative majority is now more inclined to accept laws based on a rational basis review, which is a lower legal standard than the exceedingly persuasive justification required for sex-based classifications. Politically, this case is part of a broader national debate over transgender rights, particularly for minors. It puts the Supreme Court in the position of refereeing a highly contentious social issue, with the potential to either solidify or dismantle existing protections. The emergency nature of the appeal, filed on the court's shadow docket, means a decision could come quickly, with minimal explanation, adding to the uncertainty. Prediction. A definitive prediction is difficult, but an analysis of the Supreme Court's recent actions and composition provides some insight. The court's decision in Scrimeti suggests a willingness to uphold laws that regulate aspects of gender transition, even if they are seen as discriminatory. The fact that the court took the case on its emergency docket at all, rather than waiting for it to go through the full appeals process, indicates that at least 5 justices believe the issue is of significant national importance. However, the court has historically been hesitant to intervene in school bathroom cases. In 2021, the justices declined to hear a similar case from Indiana, which left a lower court's ruling in favor of a transgender student in place. Given the current court's conservative majority, it is plausible that they may grant South Carolina's request to stay the injunction, allowing the state's law to remain in effect while the full case is heard. This outcome is more likely than a full, immediate ruling on the merits, as the court often uses its emergency docket to maintain the status quo while a case proceeds. Solutions and strategies. For advocates of transgender rights, the legal strategy will continue to focus on the equal protection and Title IX arguments, while also highlighting the psychological and physical harm caused by such policies. They can also use this case to mobilize public opinion and legislative pressure. For states like South Carolina, a potential legal solution lies in developing policies that accommodate all students. For instance, by offering private single-stall restrooms as an option for any student who desires more privacy. While opponents argue this is a form of separate but equal discrimination, it is a legal strategy that has been attempted in other jurisdictions. Ultimately, a durable solution may require federal legislative action to explicitly protect transgender individuals in schools, or a definitive Supreme Court ruling that clarifies the scope of Title IX and the Equal Protection Clause as they apply to gender identity. The current case will be a significant step towards such clarity, regardless of its outcome.